Welcome to the Contracts Review. Today we're going to cover the main parts that we learned over the course of the entire semester. And just to remind you what that was, we stepped through offer and acceptance, which together constitute mutual assent. We went over the doctrine of consideration. We went over exceptions to consideration, alternatives available in equity, and introduced the concept of equity. And then we finished with the statute of frauds, a defense which says a contract is unenforceable unless there is a signed writing for certain classes. Next semester, when we return, we will pick up with interpretation and then performance of that contract as interpreted, whether that contract was breached, whether there is some excuse for the breach, and then close with a study of damages. And so let's then talk about that very first aspect, that overarching principle, what is a contract and what contract law applies. The first question to address when dealing with contract law is which law applies, because there are effectively two regimes which can govern contracts. There is state law, and that is found in our class as embodied in the Restatement, and there is also statutory state law, not common law, but statutory law, and that is going to be in the Uniform Commercial Code. So the Restatement is actually a series of compilations of rules that have been determined by law professors and other academics who have then codified what they see as the common themes among all the different states in terms of their common law. And we're going to abbreviate Restatement as simply R period, and that refers to the Restatement Second of Contracts from 1981. In addition, we also have to deal with, from time to time, the Uniform Commercial Code, which we will abbreviate as UCC. The Uniform Commercial Code actually was produced in its form as a model rules or model law, mostly by a man named Carl Llewellyn, and then he went around the country on essentially a grand tour trying to convince legislators to adopt it, and they all have, except for Louisiana, which has it with some major modifications because of their civil law system. We also, at the outset, should remember how are we going to analyze a contract issue, and I use the formula IRAC what, which I mean you should have each issue listed separately, and you should have each rule that pertains to the issue located under that issue statement. Once you have stated the rules that are at issue, you should then analyze the specific facts of that particular case. I recommend doing your analysis on both sides. The plaintiff will argue X, the defendant will argue Y, and that will give you the opportunity to really flesh out the arguments in full. And then you finally will conclude on how you think a court will rule on that particular issue. And I like to use the signal words of whether, for issue, under to define the rule section, here to use specific facts, and therefore to indicate a conclusion. Of course, other words and ways to signal are appropriate, but these are a helpful shortcut to let the reader know what you are doing in your essay. So let's apply it to one of our first examples, a contract for the sale of a puppy. So the preliminary issue in contracts is whether the common law or the Uniform Commercial Code applies. Under UCC 2102, the UCC applies to transactions in goods. It says unless the context requires otherwise, this article applies to transactions in goods. However, we need to go further and to get an explanation of that rule to see how goods are defined. The rule explanation is found in UCC 2105. Goods are all things, including specially manufactured goods, which are movable and identifiable at the time of the sale. So, is a puppy a good? Well, yes, a puppy is movable and identifiable. I picked this guy out based on his cute little face and put a little blue ribbon around him so I could pick him out when it was time to take him home. Therefore, a contract for the sale of a puppy is governed by the Uniform Commercial Code. Now, some contracts are going to be a little more complicated. You may have a contract to install an air conditioning unit. Well, the air conditioning unit itself is a good, but the installation is a service. And so how do we know whether the UCC will govern that transaction? The test for inclusion is going to be under the predominant purpose test in most jurisdictions, and that is whether the predominant factor, the thrust, the purpose of the contract is to render a service or to obtain a good. We asked what then is a contract at our outset of our contracts analysis. And the way that a contract is defined comes from here, the restatement, right at the beginning, Restatement Section 1. A contract is simply a set of promises for which the breach of which the law gives a remedy, or the performance of which the law recognizes as a duty. And what this means is not all promises will be enforced at law. So the study of contract law is fundamentally the question of what promises will be enforced by a court of law. And so we need the rest of the restatement, and there's quite a bit more of it, to answer that question. A contract requires two things, which I think of as three things. A contract requires manifestation of mutual assent, which are really, I think, more simply broken up into offer and acceptance. Mutual assent meaning both parties have assented, the offeror assenting by giving an offer, the offeree assenting by accepting the offer, but those two things together comprise mutual assent. But even if there is mutual assent, even if there is offer and acceptance, a contract will not be enforceable for want of consideration. And we'll learn more about what consideration is in just a few minutes. Of course, there are also alternatives to consideration at equity. This also means the bargain has two essential elements, agreement and exchange. The concept of consideration is that concept of a bargain for exchange. And so we see them both captured here in Restatement Section 17. An enforceable bargain requires offer, acceptance, and consideration. And when you do an essay in my class and in most contracts classes and on the bar that relates to the formation of a contract, you should address whether there was an offer, whether that offer was accepted while there is the power of acceptance, and whether there is consideration or an alternative for that offer. And depending on the facts, you may also see if there was a defense, like mistake, misrepresentation, or the statute of frauds, which otherwise made that unenforceable.